Thank you. Well, Donal, my lords, ladies and gentlemen, thank you for inviting me here today to the Margaret Thatcher Centre and your inaugural event. It's a great pleasure to be at Gray's Inn, where Mrs. Thatcher herself was an honorary bencher. And when she was elected to that position, she wrote to Gray's Inn expressing her honour and her delight at becoming an honorary bencher, because the rule of law mattered to Mrs. Thatcher. It was, as you said, Donal, in your introductory remarks, an essential foundation of freedom and democracy, and it was a bulwark against tyranny. I think it was a product, in part, of her upbringing, the daughter of a magistrate in Grantham, and of the times that she lived through, the wartime generation, and subsequently the rise of the Soviet Union and her quest, her lifetime quest, to liberate the people of the former Soviet Union and of Eastern Europe in particular from it. But when Mrs. Thatcher spoke of the rule of law, I suspect she didn't mean rule by lawyers, and she certainly didn't mean rule by foreign courts. She, like me, would want those of us in this room today to work together to reclaim the rule of law from what it has become synonymous with in recent decades. Having been invited to speak here today, I look back at some of Mrs. Thatcher's later remarks on the rule of law, and she wrote about it in particular in her last book, Statecraft, and she foresaw in that the European Convention was mutating into a living instrument, ready to overrule ministers on borders, on energy, on freedom of speech. And 21 years later, her warning is far from just an historical footnote. It's nightly news here in the United Kingdom, as elsewhere in many Western democracies. Judges in Strasbourg have told Switzerland to rewrite its climate policy, despite it being the subject of a national referendum. The same framework leads to 3 a.m. pajama injunctions, grounding deportation flights at RAF Bryce Norton, without so much as an open hearing. Power has slipped from the green benches that I'm lucky enough to sit upon to a distant courtroom. And the British people can not just feel it, they're angry and frustrated, and they're demanding change. The rule of law was never meant to shackle democracy. It was meant to serve it. The law as servant, not master. The great conservative insight from A.V. Dicey onwards is that the law should be clear, it should be understood, and it should be equal. The moment we stuff the rule of law with every fashionable virtue, it starts obscuring it. Yet that is exactly what has happened in my lifetime. And in particular, when Tony Blair, high on his own rhetoric and self-importance, and low on constitutional caution, tore up centuries of settlement with the Constitutional Reform Act. The CRA put courtrooms on stilts and yanked Parliament from under them. It replaced the Lord Chancellor's ancient responsibilities with a quango and quango-fied appointment process that confuses left-leaning piety for legal brilliance. The result? A judiciary praised for diversity of background, yet trapped in exactly the same metropolitan groupthink that sees merit-giving asylum beyond of prison overcrowding in Belgium, and thinks family life rights stretch to foreign fast food preferences. Look at immigration. 50,000 appeals are clogging the courts because every refusal begets yet another ingenious plea. Take, for example, the shameful situation where a rape gang predator has been able to abuse our system of immigration tribunals to prevent the state from removing him from the very community where his despicable acts were committed. Common sense is not merely missing from the courtroom, it is actively excluded. The system is in total disarray, and such tribunals have diminished the respect and standing of our revered judiciary. The outcome is an affront to the rule of law. Rightfully, the public are furious. If immigration tribunals are to have a future, and they may be too damaged, that will require root and branch reform of the law, of the system of appointments, and of the activists and legal representatives currently feasting off the system. Or consider judicial review. Once the check that kept ministers honest, it's metamorphosized into an all-purpose veto. Roads, reservoirs, wind farms, coal mines, anything ambitious that can be strangled by an argument that a consultation was a shade too short or a ministerial summary a fraction too vague. Meanwhile, thanks again to a Blair-era fetish for gesture lawmaking, the Climate Change Act has gifted single-issue pressure groups a legal crowbar. Economic strategy is now hostage to process servers and procedural skirmishes. This is not the rule of law enacted, nor is it adhering to the doctrine of parliamentary sovereignty. Tinkering around the edges of reform, as Labour have indicated, and the last Conservative government attempted, will not suffice to stem the tide. It needs to be pruned back, not just to the pre-Blair state, but back to an earlier era when judges showed due deference to ministers, but above all to Parliament and to you, the people. And abroad, we show obedience to every international tribunal that fancies a swing at our sovereignty. Keir Starmer, advised by his legal lieutenant, Lord Hermer, not my greatest fan, bankrolled the handover of the Chagos Islands because a non-binding opinion from judges appointed by the CCP and the Kremlin thought it was a good idea. This is not enlightened multilateralism. It is performative defeatism. In this case, the judgment of the ICJ was even non-binding, and therefore there was no obligation on the government to comply with it. But even if it were, the British government should put Britain's interests first, every single time. And to be clear, Parliament and parliamentary sovereignty should always supersede international law. That's my view. The mission is clear. We need to look again at our asylum system and immigration courts. We should reject the Blairite consensus following the constitutional reforms enacted by New Labour and look to balance the scales for judicial review and our wider justice system. We should pull judicial review back to what it should be, an umpire for legality, not a playground for activists. Our work as the Shadow Justice team has been challenging these issues in Parliament and beyond. When the Sentencing Council tried to smuggle identity politics into our courtrooms, we called it out and we moved fast. Donald drafted judicial review papers in a matter of hours. We filed them on the Monday, and by Wednesday, the council was scrabbling for a KC to defend the indefensible. Nobody in Westminster had lifted a finger. Our team forced the debate and put equality before the law back on the front page. That is what Conservatives believe in. Equality before the law. On freedom of speech, we fought against the creeping advance of the long-abolished blasphemy laws in Britain, when the Crown Prosecution Service was busy inventing a ludicrous charge of harassing the religious institution of Islam. We put pressure on the CPS, and they changed the charge. Hamid Koskan's conviction still undermines parliamentary sovereignty, and I hope that the Free Speech Union, one of the best organisations in our country today, and their appeal sees justice finally done and Hamid Koskan ultimately acquitted. I will be doing what I can to support that. We've also taken the fight to everyday lawlessness. I was in Stratford Station at the crack of dawn, filming the tidal wave of fare dodgers, while Transport for London staff looked the other way. Incidentally, I'll be checking your tickets at the end of this event today. That clip hit 18 million views in a weekend, and it shamed City Hall into promising a crackdown. At the same time, we exposed Lord Hermer's revolving door activism, from representing Gerry Adams to ISIS clients suing his own country. Even his colleague ultimately said that he was wrong. And we haven't stopped there. We pulled back the curtain on activist immigration judges moonlighting for the very charities that litigate against the government, and demanded lethal force options for officers facing the most dangerous Islamist extremists in maximum security wings of our jails. Turning back to the topic of the day, some ask whether Parliament can even be trusted with rights. Well, Thatcher answered that. She trusted the people. She knew that British liberty depends on democratic authority. She urged us to hold fast to self-government in a realistic world where adversaries laugh at our legal self-denial. Let us honour her wise counsel. Let us rebuild a rule of law that protects rights, punishes wrongs, and never displaces the will of the people, the will of the voter, with the verdict of a distant court. We must unpick the Blairite vandalism, lift the dead hand of hyper-legalism off the throat of our economy, and restore that simple conservative bargain. Parliament enacts, ministers decide, courts interpret. That is how freedom breathes, how prosperity grows, how a shopkeeper's daughter became a world stateswoman, and how, if we have the courage, Britain can once again prove that democracy, not ruled by lawyers, is the highest expression of the rule of law. That's my mission. That's our mission. Thank you for having me here today.